Breaking, Amnesty bill for 8 million, new detention camps, and USCIS marriage fraud crackdown. A major amnesty proposal is back in the headlines. Senator Alex Padilla has reintroduced a bill that could provide green cards to over 8 million undocumented immigrants living in the U.S. since 2018. The proposal updates the immigration registry law, which hasn't changed in nearly 40 years. The last cutoff date was 1972. This bill would allow rolling eligibility based on residence length. Those who have lived in the U.S. for at least 7 years without serious criminal offenses could apply. The plan includes Dreamers, TPS holders, long-term visa overstayers, and more. If passed, economists project it could generate over $120 billion in new economic activity each year, with an added $35 billion in tax contributions from newly legalized workers. However, despite renewed attention and a press conference in Washington, there is very little appetite in Congress for immigration reform. The bill faces a steep uphill battle in both chambers. Supporters call it long overdue compassion. Critics argue it's a blanket amnesty. Whether it moves forward or not, the debate over immigration legalization is gaining fresh urgency ahead of 2026. FEMA launches grant program for state-run detention centers. The Trump administration is making headlines for an entirely different reason. FEMA has just launched a new $68 million grant program to fund migrant detention centers across the United States. For the first time, states are being invited to build, operate, and even contract out management of immigration detention centers with direct federal funding. The deadline to apply is August 8. Florida is the first to confirm participation. Its Alligator Alcatraz facility, already costing $450 million per year, will serve as a national blueprint for other states joining the initiative. Under President Biden, FEMA funds were primarily directed toward humanitarian shelters managed by nonprofits. That policy has now shifted to infrastructure for detention and removal under the Trump administration. This marks a strategic expansion of immigration enforcement, giving individual states the power and funding to house migrants facing deportation in state-run facilities. In-state tuition benefits for undocumented students under attack. In another shift, immigrant students are now losing access to in-state tuition across multiple states. DOJ lawsuits are pushing back against what the Trump administration calls illegal benefits for undocumented youth. Texas, once a pioneer in tuition equality for undocumented students under Governor Rick Perry, has now repealed its in-state tuition program after a joint legal agreement with the DOJ. Florida followed in July, officially ending its policy. The administration argues that undocumented immigrants are receiving benefits that are not available to U.S. citizens from other states. The financial loss to state colleges is significant. Florida could lose $15 million in annual tuition revenue. Texas faces an even steeper decline, over $460 million per year. In total, 24 states and D.C. had previously adopted tuition equity laws. But now, with federal lawsuits and growing political pressure, more of these programs may soon disappear. U.S. suspends all visa processing in Niger. At the international level, the U.S. State Department has abruptly paused all routine visa services in Niger, following a sharp deterioration in relations with the country's military leadership. On July 25, a diplomatic cable was issued suspending both immigrant and non-immigrant visa processing until further notice. No specific explanation was given publicly by the U.S. government. The freeze does not apply to diplomatic and official visa holders. However, it affects all other categories, including tourist visas, student visas, and family-based immigrant petitions. The decision comes months after Niger's government expelled U.S. troops stationed in the country. That move triggered wider tensions between the two governments that remain unresolved. Until further diplomatic progress is made, applicants from Niger will have no access to routine U.S. visa processing, an indefinite freeze that could affect thousands of families and travelers. USCIS marriage fraud crackdown leads to arrests and denials. USCIS is now warning applicants about marriage fraud, and the consequences are immediate. Immigration attorneys are reporting cases of green card applicants being detained directly after marriage interviews. Even if the marriage is real, a lack of evidence can lead to case denial, and in some cases, flagging of the applicant's file under INA Section 204(c), permanently affecting future eligibility. USCIS tweeted an example from Wyoming. A South African national married a U.S. citizen, overstayed his visa, and had a criminal record. He was arrested and charged with immigration fraud. Marriage fraud carries steep penalties, up to 5 years in prison and $250,000 in fines. A denied I-130 or failed interview could trigger detention or fast-track removal under current policies. Applicants who were previously denied due to insufficient evidence are now being flagged more aggressively. If you're in this situation, legal guidance is strongly recommended before attempting to refile. ICE arrests father outside preschool, dashcam footage goes viral. A disturbing case also emerged from Oregon. ICE agents arrested an Iranian-born father outside his child's daycare. Dashcam video shows the man trying to comfort his baby during the arrest. The man's family says he had already passed his green card interview and was legally adjusting status through marriage. ICE claims he had overstayed his visa and resisted arrest. Footage shows ICE officers breaking the car window to complete the arrest. The agency later stated the child was unharmed and was allowed to be dropped off at daycare first. This arrest raises new questions about the use of force during ICE operations, especially when children are involved, and how closely ICE monitors immigrants who are already in process. In today's environment, your car is not considered private space. ICE can make arrests without a judicial warrant if you're in public or behind the wheel. Know your rights, and act cautiously. Haitian fiancé visa applicants blocked under active travel ban. Haitian nationals continue to face sweeping visa restrictions. Even K-1 fiancé visa applicants from Haiti are being turned away, regardless of interview location or case status. The ban affects all routine processing for Haitians, even if the interview is scheduled in a third country like the Bahamas or Barbados. Nationality alone is grounds for denial under the ban. The only exception is for immediate relatives of U.S. citizens in rare circumstances, and even then, a waiver must be filed based on national interest grounds, which are difficult to prove. The State Department previously committed to reviewing the Haiti ban 90 days after it was imposed. That review is still pending, with no public update from officials as of this recording. Until that assessment is complete, Haitian nationals will remain barred from entering through standard family or fiancé visa channels, regardless of their documentation or intent. Marriage during removal proceedings, what you need to know. Viewers also asked if it's too late to marry a U.S. citizen while in removal proceedings. The answer is no, but the burden of proof becomes much higher. USCIS allows Form I-130 petitions to be filed even if the immigrant is in removal. However, the applicant must prove the marriage is not an attempt to avoid deportation. In most cases, the green card application itself must be filed with the Immigration Court or the Board of Immigration Appeals, not USCIS. The process is complex and often delayed. It's not too late to marry, but it's critical to show the marriage is authentic and not simply for legal status. An experienced attorney is essential in these scenarios. Citizenship after a waiver, is it safe to apply in 2025? Another viewer asked whether someone with a moral turpitude crime, already waived, can now apply for naturalization. Technically yes, but under today's policy, caution is necessary. Having a green card with a waiver doesn't automatically guarantee success in naturalization. USCIS may re-examine the underlying offense during the citizenship process. Even minor criminal offenses could be grounds for denial, or worse, referral to ICE. Applicants should speak to a qualified immigration lawyer before submitting N-400 applications in such cases. This is especially true under Trump's 2025 enforcement priorities, which include increased scrutiny of naturalization applicants with past legal issues, even those resolved years ago. In many cases, waiting or seeking legal analysis is the safest course before proceeding. SIJS program faces scrutiny over gang affiliation claims. Special Immigrant Juvenile Status, or SIJS, is also under fire. USCIS has released a series of statements alleging that gang members have abused the program to gain immigration benefits. Deferred action, which once allowed SIJS recipients to apply for work permits, has already been eliminated. Now, the spotlight is shifting to fraud allegations and gang affiliations. Applicants must monitor visa bulletin movement carefully. While SIJS remains a valid pathway, the environment is tightening, and scrutiny is increasing at both the petition and interview stages. Lawyers recommend compiling stronger documentation and being prepared for longer wait times, increased denials, or potential notices to appear for some applicants with complex backgrounds. The policy shift signals a more aggressive stance by DHS against perceived loopholes, with real consequences for thousands of vulnerable youth applying under SIJS protections. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, see you in the next video.